Good morning. Morning. May it please the court. I'm Brandon Vesley from the Florida Appellate Firm. I'm here representing Jill Ferrer, who came to observe. I'd like to reserve 5 minutes for rebuttal. Got it. Your Honor, this case is a simple case. It's one issue. Briefs weren't very long. It's a simple case, but it's about equity. It's about what's right. So the parties entered into an agreement. Before they entered that agreement, they got a joint expert essentially to opine what the husband's military pension was worth. And he came to a number. Nobody disputed it at the time. It was about $247,000.
Mr. Leslie, can I jump in?
Sure.
If I could cut through the chase.
Sure.
Your main point is mutual mistake. Mutual mistake, as I understand it, is that both parties agree as to everything, and somehow the document that's being prepared had either a typo or something, bizarre in it that should not be in that document because the agreement is still the same. Here, as I understand the facts of this case, is that both parties came together. They agreed to utilize the expert, I think it was the former husband's expert, regarding the retirement. And based on that, and everybody agreed, okay, based on the amount that he has arrived at, then they projected what would be ultimately the distribution for the agreement among the parties. I realize now, a number that later, that an actual expert in military retirement comes, says, oh, no, this was not right. He could retire early and really would make a significant change in the amount. The amazing mistake, particularly in this case, the court had an evidentiary hearing, heard all of this argument, heard even from the new expert, let's call her, with the old expert, and there's still disagreement among them. And then the court ultimately said, I don't see this as a mutual mistake. This is a battle of these experts. You all agreed to this at the outset. And because you have an agreement, the case law is very clear. You don't set aside on the street, raise fraud, and the influence and so forth, which is not alleged in this case. And that's when I'm troubled in this case. That's going to help me out as to why I am wrong.
Absolutely, Your Honor. First of all, so I think that the concept that you're limited to clerical errors or minor mistakes to set aside a judgment, which is the language that you're referencing. It comes from 1.540, 12.540. It talks about those are post-judgment matters. Okay, and so obviously, you can imagine a situation where somebody's more than 30 days from their judgment, and then they realize, oh crap, we want to set this thing aside. Sorry for that language. We want to set this thing aside, and so they're actually talking about a mutual mistake. Okay, and the court says, no, you can't do that unless it's a very limited circumstance, clerical error, something like that. But this occurred, all of this occurred pre-judgment in our situation. As soon as, almost immediately after the settlement agreement was reached, they had multiple settlement agreements. This one was regarding equitable distribution. Almost immediately after it's reached, my client realized there's a problem. Reached out, found a military expert, and that military expert said, wow, you really missed it on this one. He was allowed to retire at 53. And had he done that, well, even if he didn't, he gets money all the way back to age 53, which means there's like a $400,000 swing. Okay. And so all of this happened pre-judgment. So Mr. Felix, who's now a judge, not that makes any difference, but he was on the case at the time and representing my client, and he immediately moved to set this thing aside. And he referenced a case by the name of
Can you remind me, did he file that as a 12.54?
He did.
All right, help me out with this, because I did civil practice for a
Sure.
long time. And I've never heard of a 1.540, or I guess in this context, 12.54 motion being filed before a judgment.
Right.
It seems like what this thing really is, it's a motion to set aside a marital settlement.
I agree with you. But let me tell you something, okay? Because
I'm glad you agree
know
with that. I'm reading this, I'm like,
I do agree with you. It's very unusual because
Yeah.
12.540, you think motion for post-judgment relief, right? But if you look at the language of 12.540 and 1.540, it talks about
Well, it could be any final order, decree, or judgment, but.
final judgment order or proceeding. It says proceeding too. So I
Right.
mean, so you can see why Mr. Felix used that. And also there's a case called the Moray case
Yeah.
where this whole scenario played out exactly like this, pre-judgment. And the court referenced 12.540.
Here's
And
the
that-
thing though, if we treat this like what I think you and I agree it really is, which is a motion to set aside.
Yes.
That's the marital settlement agreement. Then at least the framework seems to me, well, then you're limited to issues of fraud, misrepresentation, and discovery or coercion.
Well, we don't want to say fraud, Your Honor, because,
Because it sounds like nobody's trying to dupe anybody.
well, I think after everybody realizes this happened, I don't think his client intentionally did this. I think he was like everybody else. My retirement age is 60. That's what it is. $247,000. That's what it is. But once his client realized that there was a big mistake, there's going to be a huge windfall to him. At that point, I don't know what you call it. I think you call it, haha, it's a gotcha at that point.
This is, because it's an agreement, it's a marital settlement agreement, it's a form of contract.
But it's equity, Your Honor. I understand there's contracts, but when you have a situation where you have an equitable agreement, where everybody's in agreement that they're gonna do this fairly and everybody's gonna wind up with the same, you can't just say, well, sorry, you.
Caveat emptor, yeah.
Yeah, you can't. This is equitable. We're in a court of equity. We have to do this right. We can't let her, my client, walk away from this thing with $400,000 less than she's entitled to, simply because a bunch of people mistakenly realized that he has to retire at 60 and not 53. But let me just say one more thing, Your Honor.
Mr. President, you're saying that it's a mistake that everyone agrees to. At the evidentiary hearing, they still did not acknowledge. Their experts still held firm to the fact that the retirement age is 60. It would be one thing if everybody agreed, oh my gosh, this is a mistake. We at the evidentiary hearing, that the experts came to the same conclusion. That's when we're in trouble, the judge, and we're dealing with abuse of discretion. The judge's order basically saying, okay, they're alleging mutual mistake. And I agree, it's a motion to set aside. The rule. Alleging mutual mistake, it's not mutual mistake. Even at the evidentiary hearing, the experts still do not agree. And he basically said, I am not in a position to set this aside, and that's my ruling. And so with that, we did abuse of discretion standard. It's a tough road.
Your Honor, first of all, he was adamant that the man is going to retire at 60, but he didn't say that NDA 2008 10 USC 12-127-31 did not apply. He didn't say that at all. He never referenced the statute. And if you look at counsel's brief, he doesn't reference the statute at all either. There is really only my expert's testimony, our expert's testimony, that established that this statute does apply. And it's black and white. If you go back and read it, read my reply brief, because I laid it out.
Let's assume for a second, pretend to understand the intricacies of military pension law. But let's assume for a second that's right. Going back to something that, would be familiar with me in contract law. Suppose you have a buyer and seller of Greenacre, and Greenacre, everybody agrees it has entitlements to build 10 houses on it. And they come up with a sale price of $1 million. Deal closes, everybody had their opportunity to do due diligence. Everybody's had a chance to, they're in an oppositional stance because this is two people on opposite sides of the table. Even more so in your situation because you have two litigants because of Jeff. So due diligence is all the more warranted. It's the supposed deal closes, and it turns out, oh, Greenacre actually has entitlements to build 100 units. It's actually worth $10 million. Would you argue, like just as contract law? Well, yeah, you can unwind that.
No, and I'll
Okay.
tell you why. I'll tell you why.
I'm glad
That
you
is a
acknowledge it.
much different situation
Yeah.
than what we have here, because in that situation, it's not black and white. There's an element of what's it worth? Let's estimate what it's worth. There's different thoughts going back and forth. And maybe building more units makes it more valuable, but there's still something. This is a situation.
Yes, that's always true in land. Being able to build more units always makes it more valuable.
I would think so. But this is a situation, Your Honors, where this is like saying he thought his 401k, his mutual fund account had X amount of dollars in it. And and then after they do this settlement based on that number that nobody disputed because that's what it said, and we didn't, need to second guess him. After you get that, you realize there's $400,000 more in his mutual fund. And so what does equity allow us to do in that situation? When you misstate something on your financial affidavit, which he did, but you get to set that aside in perpetuity. This is something that is so important in the world of family law that when you have a family law financial affidavit that's wrong, misstated, you're allowed to go back and do that forever. There's no limit on the time. So in this situation, his financial affidavit is wrong. Was it intentional? No, I'm not throwing barbs at the man and saying that this military veteran was intentionally trying to pull the wool over her eyes. What I think is he mistakenly believed it was something less, and the expert wanted to defend himself at this hearing. So he says to the court, well, I think he is going to retire at 60, so this is what I think it is. And that's not the issue. The issue is when you could retire, and the statutes are clear. It allows you to go back, based on his service to age 53. And if you add in those 7 years, it's a $400,000 difference. So all we're asking, Your Honor, is we've definitely proven enough to go back and have a hearing on this. We'll sift through it, work it out, allow us to go back, set it aside, allow us to go back and go through the motions of showing this properly, because I think the judge abused her discretion by.
Well, I think you recognize, and I'm coming up on your time, but you've done family law appeals before. Like if you unwind part of an equitable settlement agreement, you've unwound the entire equitable settlement. You can't just fly spec one thing. It opens the whole thing back up to reevaluation, which has tertiary effects.
I understand that. Obviously, the equitable distribution will.
It opens up the whole thing again.
Yeah, not child custody or those things, but from the standpoint of equitable distribution, yes, it does unwind that. And Your Honor, there wasn't a whole lot of court time involved because they had agreements on everything. So it wasn't like we're asking the court to make us redo an entire trial that lasted a week, like I do in some of my other cases. I'm asking the court to set aside a week-long jury trial. No, I'm asking you to let us go back and have a hearing on this. In equity. This is equitable, Your Honors. I'll save the rest of my time for a buck.
Okay, full 5 minutes.
In this court, Michael Martin, on behalf of the former husband. Before I start, are there any questions that you have to ask of me to begin with regard to any of the oral argument from my learning call here? I think the landscape has shifted a little bit just sitting here in the last 15 minutes, because this entire case was about a 12.540 motion and all the auspices that go along with that, and the burden of proof and the things that you need to prove in order to obtain relief under 12.540. And obviously, in my brief, I've gone through a variety of different arguments about why 12.540 is an improper vehicle to attack a settlement agreement. Case law is right on point. You're not allowed to use 12.540 to attack a settlement agreement. It's for orders, judgments, and proceedings. And therefore, that was the wrong vehicle to use. From what I'm hearing now is all of a sudden the relief requested has shifted from 12.540, which is a different category of things that we're looking at, to all of a sudden a motion to set aside a settlement agreement, which, as the court has correctly identified, involves a separate inquiry as to fraud, duress, coercion, those types of things, none of which has been pled, none of which has been proven, none of which was even part of what was argued to the court below. And I've heard Mr. Vesely discuss the fact that this is an equitable issue and we just want our day in court to go talk about this. Well, first of all, they did have their day in court. There were pleadings filed. They had the opportunity to go in front of the judge and argue all this. And in fact, the court actually gave them a hearing, an evidentiary hearing on this very issue as they had requested. So it's not as if they didn't have their day in court. It's not as if they were not allowed to present testimony, evidence, argue law about this. The trial court just disagreed with them. And as Judge Kazami pointed out, this is really an issue of there's one expert saying one thing, there's another expert saying another. In the Bear versus Bear case, which I'm intimately aware of because I was on it, this court decided effectively that if you have two experts, the court's allowed to rely upon the testimony of one of those experts, even if you say you disagree with them. So in this situation, a mutual mistake, as was cited in the brief, which we were traveling under, was, hey, there's a Scrivener's error, like somebody put or transposed a 1 and a 0, and we need to correct that because everyone agrees that's the right amount. And that is what 12.540 is meant for. This isn't a 12.530 motion for rehearing saying that you didn't see the right thing or you made the wrong factual determinations. This is a mutual mistake issue. And in this case, there was no mutual mistake. They had a hearing, contested hearing on it, and the very expert that did the first analysis, Mr. Lundy, came in and testified and was asked on cross-examination all these questions about, weren't you mistaken? And he said no. And so there is no mutual mistake. There is with all due respect, a buyer's remorse issue here where she thinks now that this was a more valuable asset than it was based upon new information and a new expert opinion that she got after she agreed to this settlement, and that was adopted and ratified. And I don't want to go away from the jurisdictional aspects of this because I think the jurisdiction here is very important. Courts either have jurisdiction or they don't. You can't create it by agreement. And this is a very odd situation because, as Mr. Vesely said, the 12.540 motion was filed during the middle of litigation. And you don't have authority, or the court doesn't have jurisdiction to do anything on a 12.540 motion during the middle of.
I don't know if that's a jurisdictional issue, maybe an improper use of procedural advice. That's
Right. But the problem is you don't really file that as the right vehicle to a settlement agreement, right? You move set aside. But the problem with the jurisdiction is the court then entered a final judgment. So procedurally what happened was they entered into this agreement. She filed in January of 24, her 12.540 motion, whatever you want to call that. There was a hearing in February on this. The court orally ruled denying it and then entered a final judgment in March. The final judgment did not contain any reservation of jurisdiction to determine any other issues. It basically adopted and ratified the settlement agreement the parties entered into and said nothing else. There was no motion for a hearing suggesting, hey, Judge, you didn't reserve jurisdiction. You still have this pending issue.
But you can appeal everything that led up to the final judgment.
But they didn't appeal it then, right? So what they did was they filed a motion for rehearing as to the final judgment, suggesting that you need to, rule on this 12.540 motion, which had been merged into the final judgment. And we get into all these issues, and I'm sure that's
deemed denied to the extent it wasn't specifically addressed in the final judgment. It's deemed denied.
Correct. And the court orally denied.
Motion for a hearing told the time to be able to file an appeal, right?
If it's a timely and authorized motion.
Right, which it was to the final judgment.
If the final judgment was final. And that's where I'm kind of getting. If you have a reservation of.
How is the final judgment not final here?
Because what
Did it force them?
No, because what they're arguing is what they argued and pled to the court in their motion was, hey, this is still pending. You can't enter a final judgment until you rule on this 12.540 motion. And the court entered a final judgment. And then they said, anyway, I think on the merits of this, I won't spend any more time on the jurisdictional aspects of it, because just on the merits of it, I think that it is clear that the court did exactly what it was supposed to do. This was a contested issue. It wasn't an issue of mutual mistake. It was, if anything, a unilateral issue of mistake. And once again, what they're asking for right now on appeal is nothing they've ever pled for. The relief that they're requesting right now, they've never pled for it. They're now suggesting for the first time today, it's nowhere in their brief. For the first time today, they're suggesting that this is really a motion to set aside a settlement agreement, and they have not pled nor proven that. So even if that were the case, there's no basis for this court to overturn the trial court's determination. And once again, I keep hearing, oh, we need to be equitable. The court was equitable. The parties came to a determination. It was a contested issue. My client hired Mr. Lundy. He performed an analysis. She had her own expert who looked at this, questioned it to begin with, then adopted it. She put it on her own financial affidavit multiple times. She put it on her equitable distribution schedule, which she attached to a pretrial memorandum and agreed upon it. She then entered into a settlement agreement. The court then adopted and ratified that settlement agreement, and she lived with it for months until such time as she decided she thought that it was worth more. The problem is you can't get out of that by the methods that she has utilized right now. And you can't just come in on appeal, even in a family law case. And I agree that family law is an equity, but you still can't come in for the first time at oral argument and all of a sudden shift the entire case to a different argument that has never been brought up before and for which there's no basis. So for all those reasons, I won't take up the court's, let me ask first, are there any other questions you have of me? No? And I won't take up the court some more time. I would just ask the court affirm the trial court's determination and let the final judgment stand. Thank you.
Especially you have 4 minutes.
Thank you, Your Honor. So let's address the elephant in the room. We have a statute that clearly does what this expert, our expert on this side, said it does. And nobody wants to contradict that. They just want to say, well, you agreed to it. That's it. We're done. You agreed to the lower number. I mean, you won't find it in his brief. He didn't cite it. You won't find it in the testimony of the other expert. You will hear it from the other side's attorney when he's trying to impeach the expert that says that it goes back to 53. You will find it there. That's the only place where anybody contradicted what that statute says. So we have a situation where there's a clear mistake. Is it mutual? I think so. I think this court can find that it's mutual. If you look at that Moray case that I cited, that we prominently put into our briefs, this is exactly what happened in that case. They did send it back for a hearing, an evidentiary hearing, to determine the nuts and bolts of the the mutual mistake. We did. That's what this court allowed. That's what the trial court allowed in this case. But she got it wrong. At that hearing, that's where the rubber hits the road. At that hearing, we demonstrated to the judge that this is completely wrong. The judge didn't get it. It's an abuse of discretion. I think this court can look at that and say, obviously, she had the information in front of her. She should have ruled that it was a mistake, and she should have undone this agreement. So, if you follow that logic that, we have an expert who has clearly shown the path for this and how much he's entitled to. We bring it back before the court under 12.540 because that's what the Moray case did, and that's what this court allowed in that case. And it went back in front of the evidentiary hearing, like the Moray case ordered in that case. And we had that hearing. So we got to that stage. Moray cuts off there because the appeal sent it back for that hearing. We got to that stage. So now we're looking at the point where the judge is looking at this and she's saying, do I have the right to do this? What is the situation? it's clear that she recognized that something needed to be done, but she didn't actually do anything. And I think the court needed to understand that this made this completely inequitable. If she understood it, she didn't take action. But I think this court should reverse that and say, yes, this needs to happen because it is a court of equity. And an equitable distribution should be fair and not completely unfair. And there shouldn't be windfalls. And this isn't a situation where you have caveat emptor, situations where, you're in business and you do a deal and you're like, oh, we got a great deal on this one. And the other side's going, oh man, we really missed it. No, this is a situation where the parties are supposed to walk out with basically equal parts. And that's not what happened here. Instead, my client ended up having to pay him $130,000 as part of the settlement. It's very unfair. And so we'd ask the court to think of it like that, because that's where we are. Follow the Morey case, follow what happened there, see that we had our hearing, and it started at that point. That's where the rubber hit the road. Start at that point and say, hey, did this court get it right? Look at the transcript from that hearing. And the evidence was all there. There really wasn't any contradiction. There really wasn't. The other expert just said, well, I think he gets to retire at 60. He didn't say that statute was wrong. He didn't say that he doesn't get to retire at 53. So that's where I think this court needs to look at it. I appreciate it very much for your time. Thank you, Your Honors.
And